In the last hours, yet another bombshell in the case of murder suspect Bryan Kohberger, charged in the quadruple slay of 4 beautiful University of Idaho students, we believe murdered as they were falling asleep in their beds. Believe it or not, in the last hours, Bryan Kohberger's defense attorney, let me look her name up again, has pulled a legal stunt. And I don't like legal stunts. I take Lady Justice and court cases very seriously, especially in a murder case, much less a 4-victim murder case. Victims murdered in such a brutal manner. I do not consider the courtroom a place for theatric stunts. But this defense attorney, Ann C. Taylor, who reportedly dumped other clients that were the Idaho victims' families to represent Bryan Kohberger, which is, I guess, more money and more fame for her, has filed this motion. This is a motion to terrorize and torture one of the 2 surviving victims. That would be a young lady, Bethany Funk, Funke. We also know about Dylan Mortensen, who also survived the slayings. Dylan, as you know, is a witness who lived on the bottom floor along with Bethany Funk, and Dylan Mortensen reportedly woke up hearing sounds in the night, didn't understand that what she was hearing were her roommates being literally slaughtered, sliced, stabbed, mortally wounded till they bled out in their own beds. She heard something and she thought actually it was one of them playing with the dog upstairs. The 3rd time she heard it, she got up, opened her door, glanced out. It's, 4 a.m., later than 4 a.m. in the morning. And she sees a male, a white male, tall, thin, wearing black, and a face mask covering nose and mouth, with bushy eyebrows. The guy walks past her, she freezes, and he leaves. If you will recall, it is our analysis that the police kept her eyewitness testimony a secret until Bryan Kohberger, at the time they didn't know it was Kohberger, but until the killer was apprehended and in jail. Remember, Bryan Kohberger's dad comes and picks him up at WSU, Washington State University, and they drive home for the holidays over 2,000 miles to the family home in the Poconos. It was only after police raid the Bryan Kohberger family home in the early morning hours, arrest him, extradite him safely back to Idaho, and put him in jail, do they reveal what Dylan Mortensen saw. Why? I believe so the killer wouldn't know there was an eyewitness, wouldn't realize they had been seen, and come back and kill Dylan and Bethany. So what this lawyer has done, this defense lawyer, Ann Taylor, is trying to force Bethany Funk out of her home in Reno, Nevada, nearly 700 miles back to Idaho, Moscow, to testify for the man she believes murdered her friends. Can you believe that? And this is nothing more than a stunt. Terrorizing Bethany Funk even more, scaring her, making her think she has to go back and face Kohberger in court, which she will one day when the real trial happens, but not for a preliminary hearing. Joining me right now, high-profile lawyer out of Jacksonville, former Fed as an agent with the FBI, and author of Arrest Proof Yourself. You can find him at dalecarsonlaw.com. Dale, thank you for being with us.
My pleasure.
I'm so mad I could chew a nail in half right now. Chew a nail in half. What they are doing to Bethany Funk, what this woman, not they, Ann C. Taylor, the defense lawyer with the public defender's office, is doing to this surviving victim. Why?
Well, obviously, they, as a defense, they're going to get information during a preliminary hearing that will help them prepare for the actual murder trial. But the odd thing for me is that probable cause has already been determined. It was determined when the arrest warrant was signed by the judge. There it is, probable cause. They make the arrest, they bring them back. So this ultimately is an effort to suppress evidence. And the way that would work, in my mind, is they would try to show that the actual issuance of that arrest warrant and ultimately a search warrant was invalid, and therefore they can get rid of all the evidence that was discovered when he got home or other places, because that was the beginning of the investigation. And if it's a fraudulent affidavit in support of it, they can then argue that the court should exclude that testimony. It's the exclusionary rule, or what we know of as a suppression hearing. But I don't think that's going to go well for them, candidly. As you know, individual states are sovereigns. And it wasn't until after the 1930-31 in our history that there was a uniform act to allow people to be subpoenaed in connection with a criminal trial. And so before that time, if you went to another state, as the organized crime people did, in Prohibition, you couldn't bring them back. You just step over a state line and you were protected. That state couldn't come and get you. And that changed after Prohibition in order to allow the government or the individual states to draw people who had fled the jurisdiction and bring them back in order to testify. But this seems like a real overreach, because you got to remember, she's only going to be allowed to direct examine her if she were to come back. That's number one. Number two, they're going to have to process this in Nevada. They're going to have to process there. So there's going to be a court hearing. That court is going to have to be apprised of all of the details of why it is that the defense believes she has information that might exonerate him. I just don't even begin to see how that's possible. She may be able to testify and say, well, look, I heard things differently than other people heard them, as an effort to get some reasonable doubt plugged into the situation. But the evidence is so damning and so broad that I just don't believe that that's going to be an effective mechanism. I do believe that it brings notoriety to the case, like you've said.
Okay, let it never be said that I do not have self-control. Because listening to you, Dale Carson, I nearly bit my tongue off. Okay? You gave me chest pains, because almost everything you said is completely irrelevant and has nothing to do with this. I don't know how you managed to work in moonshiners and the Prohibition Act back in 1930-something to what's happening now, almost 100 years later. This is not a motion to suppress. This is not a suppression hearing. What is happening on June 26, unless it gets moved, delayed, or however adjusted, is a preliminary hearing. What is a preliminary hearing? A preliminary hearing, much like grand jury hearing, is a simple charging mechanism. This is not a jury trial where the defense can bring on their witnesses and question witnesses by the state and must prove or want to prove they're not guilty. All right, that's not what this is. This is simply where a judge or a magistrate, which is a baby judge, listens to a couple of witnesses by the state, like you said, much like in a search warrant, and they think, okay, yeah, there's a question of fact, which is the sole province of the jury. The state says Kohberger's DNA was found at the scene on a knife sheath. Kohberger says, I'm not guilty, I wasn't there. Even if Bethany Funk testified, I didn't see a thing. Still, that's a question of fact. His DNA is at the scene. His cell phone puts him at the scene. He had prior relation online trying to reach one of these girls. And he says he's not guilty. Who's telling the truth? That's a question of fact. It goes to a jury. It's really simple. The state could probably get by just putting up one witness, a lead detective. Yeah, they can talk about everything that happened in the case. But they may not be that stupid. There's really no way to put that other than stupid, because once you get the lead detective on the stand, he can be cross-examined about everything. And then that's basically a practice for the defense. They need to put up couple of isolated witnesses. So that's what a preliminary hearing is. Wait a minute, Dale Carson.
Yes, ma'am.
The defense just hears these witnesses and it gets bound over for trial. That is when the defense could appropriately subpoena an out-of-state witness. But in the motion, Dale Carson, you've done this many times before, you have to domesticate the subpoena, the out-of-state subpoena, which they did not do, because under Idaho law and Nevada law, you have to have a hearing to show that the witness's testimony is material, important, critical. Here, all that Ann C. Taylor's motion says is she might have material evidence. They haven't had the hearing. So they screwed up on so many levels, much less they can't even spell the victim's name right. But this isn't worth the paper it's printed on, Dale Carson, because obviously Ann Taylor doesn't know the legal steps for an out-of-state subpoena.
Right, that's fairly clear. The Uniform Act to secure somebody's attendance from another state is universal in our 50 states, and it allows a defense attorney to do this, but it has structure, and a whole bunch of hearings have to occur. There may be one in the state where the jurisdiction rests, but there has to be one in the state where the individual resides, and it's a hearing. They have to prove to that court that there is information that this individual has that's necessary for the defense, the effective defense of the client. And I really have thought this through, Nancy. I don't really see, other than maybe a timeline issue, how her testimony could be valid at all. She was not there to witness the deaths to physically see them dead. She slept throughout the entire matter, essentially, and she doesn't have any information. But we don't have the statement that she would have given to local law enforcement that may include some items that would come out in testimony anyway without her being present. And because she's on direct examination, the defense attorney can't cross-examine her. And it's unlikely that she would be turned into an adversarial witness in a circumstance like this. But it really does hurt the state's ability to protect witnesses overall from abuse by defense attorneys.
Agree. So this lawyer, N.C. Taylor, who has performed this legal stunt at the expense of 21-year-old Bethany Funk, a survivor of Bryan Kohberger's mass slaughter right there in her home, it's just a legal stunt at the expense of those two victims. Now, wait a minute. We don't know what Bethany Funk may or may not say, because her interview with police is still under seal. We know a little bit about what Dylan Mortensen said, that she saw the killer, we think to be the killer, a white male coming out of the house. She froze. They're both lucky he didn't come kill them too. But what if, let's just spin it out, what you're saying to its logical conclusion, what if she also woke up and went to the door and saw something? We don't know that. What if she slept completely through the entire ordeal? We don't know that. What if she had seen Kohberger before, casing the house? We don't know what she might say. We don't know if she's one of the people that Kohberger tried to contact. She could say anything, and we don't know. Or she may say, I didn't remember a thing. I woke up that morning, I saw that they were lying in their rooms dead, and that's the first I knew of it. She could say that, but it's a real Pandora's box for the defense. You know, the great quote, "Be careful what you ask, my dear, for you will surely get it." Putting her on the
Well,
stand may be a bombshell for the defense because we don't know what she's going to say.
well, but there's another interesting protection in all of this. If it's inconvenient for her to come back to Idaho, here's what inconvenience can mean. If she's suffering from PTSD, she may be medically not permitted to come back. And that's a whole nother series of hearings with experts testifying one way or the other. And it takes us away from the general focus, which is this individual is alleged to have slaughtered in cold blood 4 young people in the middle of the night and fled the jurisdiction.
You know, that phrase, "be careful what you wish, for you may surely get it," that goes all the way back to Aesop's fables, which are very old, and truer words were never spoken. I wonder what is going to happen when Bethany Funk gets on the witness stand, and she will, at the time of the trial, get on the witness stand. But to ask her to come to a preliminary hearing or try to force her to is completely out of legal bounds. There is no precedent, which means legal cases that have been appealed and affirmed in the past that speak to this exact issue. There is no legal case that would demand her to come back to Idaho, and there is no statute demanding that she go back for a preliminary hearing. In fact, it's made out very clearly in the law the defense has to show or demonstrate that she is a material witness. And in this motion by N.C. Taylor, it says she, quote, may be a material witness. They don't know because none of us know what's in her police report. So what do you chalk this up to, Dale Carson?
Well, it's a desire to get back in the public view and to perhaps polarize prospective jurors. But of course, you and I both know that she could voluntarily come back. The fact that she's resisting is, from my perspective, a good thing. I don't think victims of these kinds of cases should be subjected to repeated interview by people connected with the case, wanting a particular outcome, as clearly a defense attorney does.
You know, this exact lawyer, N.C. Taylor, who is the chief of the County Public Defender's Office, was previously representing one of the Moscow stabbing victims' parent on another unrelated matter. And as soon as Bryan Kohberger's case came up, she dumped them and went with Kohberger. It's very, very interesting to me. She represented 3 of the parents of 2 of the victims. 3 of the parents of 2 of the victims. Kara Kernodle, the mother of Xana Kernodle, in 4 cases. So wait, let me get that straight. She represented one victim's parents in multiple counts. Now, what do you make of that conflict of interest, Dale Carson?
Well, I think it speaks to her ethical integrity or lack of, but I also recognize that this is appointed counsel, and they may have just a small number of individuals who are capable of handling what ultimately is going to be a death penalty case. You know, that requires, as you know, certification and many steps. So those people are fairly rare in the justice system because, of course, the desire to execute someone in connection with a crime is fairly rare as well.
Well, I will give her this. She filed a withdrawal of representation from the parent and then took on Kohberger, which is, you know, you have to file a withdrawal before you can get off of a case, and the court has to allow you to withdraw from the case. A perfect example would be Kirk Nurmi, Nurmi represented Jodi Arias, and he tried and tried and tried to get off her case. The court wouldn't let him off because the court felt, I believe, they couldn't get another lawyer up to speed with the nuances of Jodi Arias' case in time for trial. So Kirk Nurmi had to stay on the case. You can't just say, here's a withdrawal, bye. No, the court has to allow you to withdraw from a case. So she, Ann C. Taylor, was allowed to withdraw from the case of one of the slave victims' parent and then go to Kohberger's case. So, by the letter of the law, she did nothing wrong. Dale Carson, not just as a veteran criminal defense attorney, but as a former FBI agent, you've dealt with a lot of crime victims. These two young ladies, Bethany Funk and Dylan Mortensen, are dealing with not only waking up to find the roommates that they love, that they live with, dead, stabbed and sliced dead, right above them. But they're dealing with possibly survivor's guilt of thinking, wow, I heard something and I just went back to sleep. I didn't realize what was going on. What if I called 911? What if I could have saved their lives if I had called 911 earlier? Obviously, they didn't know what was going on upstairs. So they went back to sleep or slept through it. So there's a survivor's guilt, and there is the shock of seeing this crime scene that they're dealing with.
I see this in FBI agent shootings and in police shootings when I was down in Miami. If you didn't get shot when somebody else was being shot, you always think one of your own officers, I'm talking about, or one of your own agents. You think back and say, damn, I could have done this or I could have done that. There's all of those things because we're trained to deal with these situations. Yet when things really happen quickly, as they do, your reaction may not necessarily follow your training. And the result is afterwards you think, oh, gosh, why did I do that? Or why did these other people do this? And why are they dead? They were really good people. And you tend to have what's known as euphoric recall. You recall your relationship with the people that are deceased in a way that makes them much more favorable than they perhaps were in real life. And that is a menu for aggravation and injury personally to you, because you feel like you could, as you say, you could have done something. When the reality is you could only operate on the facts and your ability at the very moment all this happened. And you remember, these are children. I have actually seen men stab one another in a homicide. And I can remember putting the stabber in the back of the car, and he would ask me repeatedly, now this is a caged police car, he would say, did I kill him? Is he dead? And I would say, my response to him was rather cold. I would say, yes, and you killed him. So your reaction to the behavior of other people is often controlled by what you witness and your own life experiences as you bring them to the situation.
Just the way you recounted that story, that you recall like it was yesterday.
Oh, yeah.
Yeah,
Go ahead. Cigarettes. Over a pack of cigarettes now. That the one brother killed the other. A pack of damn cigarettes.
You know what, Dale? I have relived so many times. I mean, millions of times. My fiance's murder, and seeing his part of his body in the casket, and imagining what he went through at the time of the killing. And I didn't even see the crime scene. These two girls saw the crime scene. They were nearly murdered themselves. I can't imagine where their mind goes at night when they try to sleep, or all during the day, and now this is just like a stink bomb at the dinner table, this subpoena to make her come back to court, and they don't even have a leg to stand on. For doing this, I think, is just tormenting the crime victim.
But it's abusive process is what it is. It's an actual civil crime.
Well, this is a tiny peek what we have to look forward to at that preliminary hearing, now set for June 26th, it could move, and they very often do, much less the trial. And there will be a trial. I guarantee you there will be a trial. What do you think? Is there any way that Kohberger is going to be allowed to plead out?
Well, of course, that's a decision that he and his lawyer get to make. I mean,
well, I don't know about that. They've got to be offered. They've got to be offered a deal first.
Well, they can plead straight up to the court.
Well, really, because the court can then sentence as it sees fit, and it's death by firing squad there.
Absolutely, the court.
The court could say, "Great, you can just march right on out to the basketball court. We're going to have the death penalty right now."
Well, it does offend me as a practicing lawyer that it does take so long to get to the end results of these cases. I mean, the longer this goes on, the more opportunity.
I just said they could march him out and shoot him dead on the basketball court at the courthouse, and you didn't say anything. Wake up, man. It's lethal injection there, but if they don't have the appropriate drugs, which there's a shortage of for the needle, he can get the firing squad. I guess that's something for us to think about. Carson, are you with me?
I am, and I was just processing the pain that those victims would reabsorb if they are forced to testify in the case. Because people don't really understand that the victims that the friends, the people that they cared about and lived with, when they found them in the condition that this individual is alleged to have left them in, cut up, bleeding, they were in rigor at the time that they were discovered, and they wouldn't. You
actually just made my stomach hurt when you said that. When I think about those students, those beautiful 4 students in rigor mortis, when your body starts stiffening up.
Well, when you touch them, they're cold as ice, and it's just abnormal. The silence that attends to a homicide is something else that we never think about.
When we say plea, can we be clear, Dale Carson? The state has to typically offer a plea deal. The defense has to accept it after much haggling, or they can enter what is called a blind plea with no deal attached, and the judge can then sentence to whatever he or she thinks is appropriate. And a plea, unlike a jury trial, is very hard to appeal.
Well, that's right. In fact, in most of those plea deals, there is a provision that says you can't appeal the outcome.
I would always put every defendant under oath before they entered a plea deal and say, is this what happened? And I would give a rendition of the facts. And are you pleading guilty to this? Do you agree that is what happened?
Yeah, that's exactly what happens. It's called a proffer. The state will simply provide information of what they believe they could prove at trial.
With every single guilty plea, because I did not want them jumping up later, appealing their guilty plea, causing me to start over from scratch, assemble all the witnesses, and try the case with the jury. So I would put them under oath with their hand on the Bible to make them agree. If they wanted a plea deal, here it is, but you've got to admit to the facts so that later it could not be somehow used against me as some sort of bullet right to my neck. So it had to be sealed with an oath and perjury as a consequence of going back on the deal.
I think that's a great idea. That's what's done here in Florida. The difference in Florida is that a single prosecutor can file what's known as an information, which simply says, I believe based on the facts I can prove this case beyond a reasonable doubt. And there is no preliminary hearing unless a defendant asks for it within a specified period of time.
It's basically one person, the prosecutor, drawing up an indictment. An indictment, of course, is with a grand jury. Dale Carson, if this is any example, any taste of what's going to happen, it's going to be a cat fight, a fight to the finish in State v. Bryan Kohberger. And you know what I have to say to Ann C. Taylor, the defense lawyer? Bring it on, woman. Goodbye, friend.